Live stream audio test, 1, 2.
Is resumed, ladies and gentlemen. I was just going to say we'll obviously continue with the Housing Land Supply Roundtable session now, but before we move on with the Council's first witness, perhaps we can just spend a few minutes just discussing how we all see the rest of the inquiry panning out and what dates we might need to think about reserving. So if you can just bear that in mind for when we've finished going through the Housing Land Supply, please. So, I think we'd finished off the the western villages. So we've got down now to the allocated sites. So first one on my list is 605 Millcross site, Clevedon. Just remind me of your page number, please, Mr. Patterson-Neal.
Happy to, sir. Page 50.
Yep. Okay. And
Page 83.
sorry.
83.
83. 50 and 83. Thank you. Okay. Thank you. Yep.
Okay, sir. So this site, there's been no planning application submitted for the site. It's allocated for 70 dwellings. It was previously proposed for a new hospital site. A key aspect here is the need to undertake flood risk assessment, but also sequential and exception test will be required for the site. It's worth noting, sir, there's a theme that's common, and you'll have seen it repeated across a number of these site allocations. A point that I've summarised at the beginning of that section in my evidence on the preceding page in para 671, where I've referred to the site allocations inspector on the Part 2 plan in 2018, noting in a report, also commenting about the uncertainty about delivery of the strategic sites, what we've just been talked about before lunch, but recognising a number of the other allocated sites are affected by technical issues to do with flood and surface water management. And at the end of that quotation, there's the point made by the inspector at the time that each of these sites, this consideration could add to the lead-in time for the start and affect viability and delay implementation. And I think it's worth just alighting upon that because it's quite an important aspect of a number of these allocations. There is the council's announced in 2020 on this site, that'll be purchased from the NHS property organisation in a deal, a so-called back-to-back deal with Alliance Homes, which is referred to by the council in its evidence. And this is to provide 60 affordable homes rather than the 67 to which the site is allocated for. So again, there's a bit of a numerical difference as a starting point there in any event. And I've referred to the Alliance Homes' own website, which confirms the fact that they're at an early stage of that project in design terms. And the council's evidence on page 83, there is an email from the head of land at Alliance Homes, and I've referred to this in my rebuttal. R14 on page 5, if you have that. There's
Okay.
a couple of points just to highlight really that there's a reference to the fact that Alliance are working through technical viability issues, number one, and number two, the consultant team at the time had yet to be appointed, so there's no design team in place at that point in time. They refer to a timetable based on milestones, which suggests to me that's rather indicative at this stage. And I suggest that timetable should be treated with a degree of caution, clearly with viability matters remaining outstanding and a design team not in place, together with that quite key technical matter to do with flood risk and surface water management that's yet to be addressed. And because they don't have a design team, I think it's reasonable to assume they've yet to consider the implications of that. In my view, this remains uncertain in terms of delivery, and no detail, reliable timetable put forward for the delivery of this site. So I conclude that 67 units should be removed, but in any event, even if you prefer the council's position, it should be 60, because that's what that proponent is indicating the capacity of development they're actually looking at in any event.
Okay, Mr. Richards.
Thank you.
Sorry.
I agree that the council's figure should read as 60 on the basis of the Alliance Homes scheme. The email that was referred to, a copy of which is set out on my page 83, is from Alliance Homes, who did acquire the site, as was mentioned, directly by the council. We procured it from the NHS. It was surplus to their requirements. They redeveloped the existing hospital site instead. So the council purchased it and immediately transferred to Alliance Homes for them to deliver this proposed scheme. It's going to be a 100% affordable housing scheme, and the grant funding has been secured from Homes England already. As is said in there, the design team will be appointed during quarter 4, 21-22. That may actually have happened by now, although I haven't got an update since that 6th of December date. They were definitely seeking to appoint them. And the planning application timeline is for summer 2022, with a start on site as advised by Alliance Homes themselves, 2023, and an 18-month build programme. Therefore, that fits with the trajectory that we've set out, albeit with the change of the 7 units. So in year 3, it will be 30 dwellings, and in year 4, 30 dwellings.
Right. So you're saying 30 and 37 on the trajectory?
On the copy that you've got, yes.
So 30 and 30. And the council's view is that that's still on target for the years you said?
Yes, as confirmed by the Alliance Homes email.
Okay. Anything back from yourself, Mr.? No, okay.
No, sir.
Right, so next one.
Next one is
637.
Now north of Churchill Avenue, Clevedon.
Yeah.
So that's page 50 again, and 84.
Yes, 84.
Right, page 50, 84. Yep, okay, thank you.
So again, no planning application submitted. It's allocated for 44 dwellings. Again, this is a site where flood risk assessment sequential exception tests will be required, with sufficient space allowed for the maintenance of the existing water courses and drainage features, as referred to in the site allocations plan itself. I've recently looked at the land registry. Council still owns the site. That's really confirmed by Ms Richards' evidence, in that she indicates the council is seeking to undertake a consultation on development options. And the council's executive meeting I referred to in June of last year had a report with regard to development programme and acquisition and development of certain sites in Western Town. It's restricted items. There's no detail of that on the website in terms of the detailed consideration, because it related to commercial matters. But it does reveal that the potential purchase of sites was approved in principle. I've referred in my appendix 30 to a press article that states discussions are at an early stage with interested affordable housing partners. However, there's, with the significant site constraints that I've referred to, without any specific proposal for the site or firm details of progress towards a planning application, the council hasn't offered any clear evidence to demonstrate a realistic prospect, again, of this site coming forward within the 5 years. So I've concluded that 44 should be removed from the supply.
Okay. Ms Richards.
Thank you. It's all actually really set out on my page 84. The site is owned by the council. It's within the council's gift to develop it, and they've confirmed that the intention is to do that within the short term. It's part of the 5-year development programme. Consultation I've referred to there is to be held on development options. I now understand, since that was written, the consultation is scheduled to open in March, and the trajectory has been prepared with the head of development and placemaking. So that allows 3 years for the planning processes and procurement of a development partner. And I've got 22 completions anticipated in year 4 and 22 in year 5.
Okay, thank you. So we've got the
Next one I have, sir, is 668
668, yes.
Somerset Square. So that's page 52 and
88.
thank you.
Yep, okay, so 88, sorry, 52.
52.
Yep, okay, thank you.
So this site's allocated for 28, part of the Crown Glass Shopping Centre in Weston. An outline application was submitted in March 2015, which remains undetermined. The reason for the duration of that application remaining undetermined is identified really in a report presented to the Council's Executive in 2017, which I've put in my Appendix 31, and it refers to ownership issues holding up progress of the planning application, which is, quote, unable to progress at present. So that application's seemingly run aground. A more recent article from local press from January last year confirms that the redundant college building has been acquired by an organisation called Developments Bristol. Plans to develop some ground floor retail with apartment scheme above. The Land Registry confirms the site's owned by Media Developments NLC Limited. I assume that to be a holding company, specifically special purpose for the site. It's reported that the developer in question is in discussion with the Town Council, the North Somerset Council, as well as owners of the nearby library and the town centre owners, Praxis, with potential for the library site to form part of a wider proposal with a commensurate relocation of the library. Discussion said to be at an early stage. So there's clearly a land assembly process that's being considered, which is impacting upon the timeline to progress this site. It's had previous issues in terms of ownership, which has meant previous proposals have not progressed. There are no firm details at this stage of the preparation of a future application or its makeup or sort of extent of the site, what that might be and what's in and what's not. And it's evident that the 2015 application is not and is very unlikely to progress any further. I think that's probably fair to say. And therefore, again, there's no realistic prospect or clear evidence of this site delivering within a 5-year period. There's too much uncertainty, I think, remains with the development.
Okay, so your page 88, Mr. Richards.
Yes. So it is fair to say there were previous ownership issues and that these have now been resolved. The site's been acquired by the local developer. They have a proven track record and have actually delivered an adjacent site to this within the last 2 years, delivering 10 houses. That developer has quarterly meetings now with our head of development and placemaking, and they've advised her that they intend to submit their full planning application, a full application, not an outline one, in 2022. We've therefore applied a cautious estimate and do expect completions on this site within 5 years.
So, sorry. 468. So this is 28.
Yes.
28 in the final year of the 5 years is how you're viewing that. Yeah. Okay.
I think, just if I may say a brief point, the council, you'll notice in the trajectory, as indicated, assume 28 in the final year. If an application is being lodged this year, that suggests quite a significant degree of a lack of confidence in that coming forward for a relatively small number of units. If an application is being advanced, we're told in short order, although there's no written confirmation of that. So I think there is uncertainty there. I think the council's fairly reflecting that in its more cautious approach to when those units may deliver. And in my view, the balance weighs in favour of excluding that because of that continued uncertainty.
Any further comments, Mr. Richards?
No, as I say, that was a cautious estimate, remembering that the base date of this trajectory was April 2021 before we were advised of the full planning application being prepared.
Okay. So,
Next site's there is 644,
yes.
land at south of
Downside,
Downside, Porter's
yes.
Head. So that's page 52 again, and
And 89.
89.
Thank you. Okay. 52, downside, 644. Yep, okay.
So this is allocated again for 23 homes. No application made to date. The council does own the site, as confirmed by Ms Richards. There's no clear evidence of delivery, no details put forward by the council of progress towards an application. Council's evidence refers to a short-term development programme consultation yet to be held, but to be held during 2022 on options for the site. But there's nothing put forward as to who the developer may be, the makeup of a scheme, any details of any proposal, and therefore the timing associated with that application that would be necessary to bring the site forward. So there's just really an absence of clear evidence here for the delivery of that site within 5 years.
Mr Richards.
Thank you. Again, council-owned site within the short-term development programme, the consultation being proposed to be held in March. So again, it's within the council's gift to deliver this site, the benefits of which being twofold, revenue and housing completions. The consultation will focus on the development options, engagement with local people, development partner to then be procured, and as I say, we've put this one in for year 4 within the trajectory, bearing in mind it's a relatively small scheme of 23, and that timeline is confirmed by the development and placemaking manager.
Okay. Right, okay, thank you. So 645 Station Gateway.
So this is page 53.
Yep.
95.
And 95, yes. We skip on a little bit. We agreed on a few in between,
Yeah.
I think.
Making progress.
95. Yep, okay.
So this is a site allocated for 300 dwellings. Council assumes 200 of those in the 5-year period. Includes land at Sunnyside Road, Locking Road car park, station approach, and part of the Tesco car park. It's one of those sites requiring flood risk assessment, sequential exception test. I've indicated the council's website, what it states about that. There is an SPD for the town centre regeneration that identifies that a detailed master plan for the area will be progressed in partnership with owners and developers and presumed Network Rail, who, I don't know whether Network Rail own an element of the land, but clearly it's land surrounding the station. For a mixed-use development, it's clearly a complex, challenging town centre site. There's no evidence of the production of that master plan as yet, and no planning application has been put forward. It will take time to deliver, I've no doubt. It's an important, very important, clearly clues in the name, a gateway site, quite literally, and I think it's obviously a site the council will want to ensure that that's done well and appropriately. But in my view, there is, again, insufficient evidence of the timeline for that. There's no doubt there'll be public consultation that will need to be undertaken on the master plan prior to even getting to a planning application. So we don't have any information put forward by the council to indicate the time horizon and the prospect of an application, which can give any degree of confidence that that will be delivered within the 5-year period.
Okay, sorry, this one you say covers some car park areas as well, yes? Locking Road car parks.
Yes, on my page 95, there is a, if you've got a colour version, hopefully, a red shape showing the wide allocation area.
Yes, I've got it now.
That brings me on to the fact that that was an indicative allocation at the time on the basis of land in control of Homes England. Now, that hasn't been developed as yet. Mr Patterson's Neil's right. The council see this as a gateway site and would like it done well and appropriately, but also quickly, so much so that the council are now in the process of acquiring the site to accelerate delivery. We expect that procurement to be completed by the end of March 2022, March this year. That will then be in the council's ownership, and a commissioning plan for a developer. It went to executive committee in February and was endorsed. So we're looking to launch the process in the spring and appoint a development partner thereafter. This is all set out on my page 95 for you. With regard to the car parking and National Rail queries, clearly the wider allocation does cover the railway station area. That was to deliberately incorporate the two larger parcels to the north and south. It's intended now by the council that this wider site will come forward as two phases, called the Locking Road car park site, which is the large one to the north, and then Sunnyside Road to the south of the railway line. I still anticipate that there will be the 200 units come forward within the 5-year period from the wider site. The total allocation, the SHLA confirms the capacity is 429, and we expect the rest to come forward beyond the end of the current plan period.
So 200 in this 5-year period, and you say 229
And
still,
229
still
beyond, yes.
on this overall development? Yeah.
Yes.
So I'm going to come back on this actually because there's a legal point here, because Ms Richards has slightly elided two separate concepts, the acquisition of the site and the procurement of a developer. The procurement of the developer, page 95, tells us that a commissioning plan for the brackets future procurement developer is scheduled to be considered by the executive in February. Just to be clear what that means, because I did the main court of appeal case on procurement of development agreements, that it will require a competitive tender process, under what used to be the OJU process when we were in the EU. There's now a UK post-Brexit version of that. It's not something that's quick. That's been open competition as a matter of law when a council procures a developer under a development agreement. As a matter of public procurement law, it's not a straightforward process, and there are rights of challenge by unsuccessful bidders. So if it's inadvertently applied that this will all be sorted in or shortly after February, that is way wide of the mark. I'm sure it's not deliberately implied, but just to be very clear, it's a separate process. I don't know if Mr Patterson-Neal wants to...
Okay. Any comments back on that?
Nope, not at all. Just to say that, as I said earlier, the 200 units I've not gotten until year 4 of the trajectory 4 and 5.
Just make sure I'm following that. So, yep, okay.
This commissioning procurement for development, when is it going to be considered in February?
It has been considered in February. The executive meeting has already taken place.
So what did the executive decide precisely? What was its resolution?
To proceed.
To proceed. So you have the council's cabinet agreeing that you will procure a developer for this site.
Yes.
And when are you going to start that procurement process?
I am advised that this will start within the spring of this year.
Right, so you're going to begin to procure the developer in the spring, and when do you expect to complete that process?
I would need to take advice on that.
All right, well, we better know. So can we inform you as to when we expect the procurement to be completed?
Yep.
Thank you very much.
Let me note that. Okay, thank you.
Favour, without me, because I advise on procurement. So there's the procurement I'm advising on now, where the procurement process is just gone to tender, and the decision to do a procurement was over a year ago. This is not straightforward. Just as a sort of flavour.
Okay. Yep, thank you. Okay, so next
Next one is 602.
Sorry, just let me shuffle papers again. So, yes, 602
Mead Vale.
Mead Vale Shopping Centre.
That's the one, 54 and 96.
602. Yep, okay.
So this was allocated for 40 dwellings. The site requires flood risk assessment sequential exception test. That's one of those. It's allocated for mixed use, including residential, and an outline application was submitted in October 2020. The application has been under consideration since that time, but as I've identified and enclosed in my Appendix 33, this application is locked in an issue regarding viability, where it's quite clear the applicant and the council take differing positions, and this is really to do with the ability for the site to generate affordable housing, other planning obligations. And I've quoted the viability report submitted back in April, almost a year ago now, which concluded from the applicant's side that no affordable housing, or a scheme with no affordable housing generates a certain land value, but that's still below the existing use value. And therefore it would not be viable based on the provision of any affordable housing or indeed any other wider planning obligations as well. Council, understandably, commissioned its own independent assessment of this, and I've enclosed that in my appendix, where the council takes a different position. Principally, it seems to do with other Section 106 contributions. So the report acknowledges the applicant may be willing to consider a lower profit margin of what's said to be 8%, and the council's advisor is indicating that both 106 contributions and 21% affordable housing could be sustained and still the scheme being viable. But there's no further correspondence available on the council's website, so it's quite unclear as to the outcome of those discussions. They're obviously quite vital to the specifics of that proposal being put forward and advanced. So there is a serious viability issue and therefore availability issue, which goes to the heart of deliverability for this site. And given that fundamental outstanding concern, despite the submission of a planning application, and really the significant period of time now elapsed, this is not something that's going to be resolved quickly. Clearly it hasn't. I mean, it's been going on for nearly a year with no prospect, seemingly, or evidence of an early resolution. That my concern is that this will take further time to resolve, and ultimately there may be an impasse that's unreconcilable in terms of the specific proposal currently being put forward. So, in my view, one should discount the 34 dwellings from the supply for this site. There's no firm details for that to actually come forward.
Okay, so that's 96. So your note, Mr. Patterson-Neal, says unclear as to the outcome of discussions, and they were back in September.
Well, the last submission was the council's advisor in September responding to an April submission from the applicant in question. So there's nothing further. Mr. Richards may be able to assist you, sir, but that's the information that's publicly available.
Yeah. So any update on that, or any update generally?
Yep. So in general, this is an allocated site for underutilised car parking, was promoted by the landowner for allocation, and the submission of that application is clear intent to deliver it. Mr. Patterson-Neal's correct. There is a viability case being made by the applicant. That in itself isn't unusual on some of these more challenging previously developed sites. The council are continuing to negotiate. As has been said, the applicant may be inclined to now, to get it developed in the short term, take a smaller proportion of profit. Those discussions are still ongoing. Last time I checked with the case officer last week. That said, there's no in principle objections to the site. It's suitable, it is available, and in our opinion, deliverable within the 5 years.
Okay.
My only further point really is just to reiterate, sir, that achievability is obviously a part of deliverability, and that's the issue here, not suitability, but achievability.
Okay, thank you. Right. So 647 next, isn't it?
That's right, so that's the Thornsville school site, Selworthy Road. So this site is allocated for 45 homes. Again, one where a flood risk assessment sequential test required to be addressed. No planning application made to date. Council's indicated and provided correspondence with Alliance Homes. It's indicated that Alliance own the site. I've actually checked the land registry. I'm not necessarily disputing that, but the land registry still confirms the council's the owner. It may be a question of it not being registered with the registry yet. So the council may be able to help you further with that. But there's no, and there is an email, sorry, from Alliance referring to a timetable for summer of this year, but acknowledging there's no detailed build programme or clear build programme. Viability issues are raised in that email in terms of the specifics of the proposal they're looking at. And in my view, this doesn't represent sufficient evidence of clarity that there are still issues to be resolved, quite significant ones of viability, before any particular scheme can be advanced. So without those further specific details, I don't have sufficient confidence to say that that site's capable of delivery in 5 years.
Okay. So, again, Ms. Richards, please.
Yes, as per my page 99, which includes a copy of the email correspondence, Alliance have purchased the site, albeit recently, so that might be why the title hasn't yet been transferred. Ms. McQuat, who is the head of land and business at Alliance, confirms in that email that they have purchased the site and they do indeed own it. They've also appointed design consultants, and with regard to the viability issues mentioned, they have regular meetings with our housing enabling team. They have a proven track record of delivery within North Somerset. Their current programme is set out in that email, and also a reference to them intending to develop this with modular construction units to speed up delivery, and their full completion is anticipated by 2025.
Okay. And that's, sorry, that's 45 dwellings, isn't it? Yeah.
Yes,
Right.
that's correct.
Okay. Right, thank you.
Next one is 648, former Sweat FA site, Winterstoke Road.
648, right. Yep.
On page 100. So coincidentally, it's another 45 dwelling allocation. Again, one that requires a flood risk assessment sequential test analysis, also a land contamination assessment and a health and safety executive consultation. No application made to date. Homes England own the site. Check that with land registry. Recently been marketed by Alder King. Marketing brochure refers to a pre-app for 37 dwellings rather than 45. But no clear evidence of delivery beyond that, no details of the specifics of any planning application proposal. I appreciate the Council's evidence indicates that's expected imminently, but we have no further detail on that. So absence of that clarity, and particularly those quite key issues and technical issues that need to be addressed on this site, I have insufficient confidence this site's capable of delivery in 5 years.
Yeah, so again, that's another 45, isn't it?
I've got it in my part of the trajectory for 37,
Yeah.
as per so the allocation was for up to 45. The pre-application that was submitted and received a favourable report was for 37 dwellings, so that's the capacity I've taken. I'm advised by the Strategic Developments Manager that we do expect the planning application imminently for the scheme that came forward as pre-app previously. That's clear intent to deliver, as far as I'm concerned, and to allow time for that planning application process and start on site. I've got it down for year 4 of the trajectory for 37 dwellings.
I'm sorry, who's preparing the planning application?
Homes England.
Sorry, you said 37 in year 4.
Yes.
Okay, thank you. Right, so
Next one is 611, Walliscote Place.
611, yeah. Let's go, please.
The former police station.
sorry, where are we on?
Sorry, forgive me, page 56.
50, yep, 56 and 101.
101. Yeah.
101, okay, thank you.
So this site's allocated in the site allocations for 70 homes. It's a mixed-use proposal, includes the demolition of the former police station building and the conversion of the Magistrates' Court, which is a listed building, with some commercial development on the footprint of some other existing buildings. There was an EIA screening back in 2017, and then a planning application for the demolition of the former police station. An action you can actually view and it's on the council's website if you're interested. The demolition of that, which has now occurred, but that was an application just for the demolition of that building. I've made reference to a local press article from this, June of last year to do with a bid from the council for circa £1 million for kickstart funding to help the redevelopment of that site. And a quote from the Placemaking and Economy Councillor, Councillor Caniford, who refers to the fact that the council is really keen, obviously, to bring forward the site, but the issue is to do with the fuel tank, which remains, notwithstanding the demolition of the police building, and the cost of that could be prohibitive to any developer. The evidence provided by the council indicates that funding has been secured for remediation and enabling works. It's not entirely clear whether that's to do with the same fuel tank or otherwise, but I'm sure the council will confirm. The council's then again going through a marketing and procurement process, we understand, and a timetable set out in Ms Richards' evidence, but there have been clearly serious financial and contamination issues. We have a timetable put forward which I've commented on in my rebuttal in page 6, R17.
Okay.
And really just with reference to the timetable that's now put forward, procurement, marketing, then procurement during 22, an application in 23, start on site in 24, and completions 25, 6 thereafter. Reference is made to the fact this would be an apartment scheme, so the units are all likely to be delivered in 1 year because it's a single building. They're all going to be completed together, which is understood. But and this is, the council assumes, in the very final year of the 5-year period. So there's no developer appointed, of course, and Mr. Banner's already explained that process of procurement which the council's embarking on. So even if the funding issue is resolved, there's no detail given about the timetable for the remediation of the site, first of all, which, given the quantity of money involved, must be significant. We know the complexities of procurement, which are also required, and then the developer being appointed. It's an important and sensitive site with a listed building, so that's not a straightforward proposal, of course. It will take time to be formulated before that comes forward, and we just don't have, again, clear evidence, in my view, to support that timetable at this stage. There are a lot of uncertainties and complexities which need to be resolved.
Okay, Ms Richards.
Thank you. So page 101
Yep.
of my evidence sets out the trajectory and timeline as provided by the Head of Development and Placemaking. This is another flagship site for the council, really important, hence why the demolition, we proceeded with that and secured the £1 million. That is to address the fuel tank issue. I apologise if that wasn't spelled out clearly. You can see the site if you step out of the front of the building and it's on your right. So this is another part of the council's development strategy, and this is set out as a priority site. So we think that timeline is realistic, and the 70 completions within year 5 are a realistic prospect.
70, there was an 80 figure referred to earlier, wasn't there, as well? Have I got that wrong?
70 for this one.
I think it's about as allocated for 70, but there's a screening opinion for 80.
Sorry, I've got myself confused on the pages here. Yep, I've got it.
Sir, if I may, I welcome the clarification about the funding and what that is towards, which is helpful to you, sir. But I think also what would be of assistance to you is to understand whether the council has any evidence to do with the timeline for that remediation.
Again, that's something I can take away and provide if that's helpful.
Yeah, it certainly would be if that's available. Thank you. Okay, so
Takes us to 650.
650 Dolphin Square. Yeah.
That's my page 57 and 103.
Yep. Yep. Okay.
So allocated for 220, the element in question is phase 4 of a redevelopment. First phase was the Premier Inn, Brewers Fair. Phase 2 is a multi-storey car park. Next phase has leisure. There was a recent temporary planning permission granted in June 2020 for a cycle hub for a small part of the site. But the officers, the important point here in my appendix 37 is that the officers' report at the time indicated the redevelopment plans have been placed on hold. As such, is now unlikely to be implemented in the form initially envisaged. To date, no planning applications have been submitted for residential. Press article from the early part of 2020 indicated a fundamental issue of financial viability. And a quote from Jenny Ford, the head of the council's development team, indicating that the council were looking at meanwhile uses or short-term uses, pop-up restaurants, etc., other cultural uses in the interim. Clearly an issue with viability here, which goes to the heart of achievability and therefore deliverability. It's understandable the council wants to look at temporary uses given its central position in Weston and significance as a site, but there's no clear evidence put forward for residential within 5 years, and therefore I've excluded it from the trajectory, as I don't believe there's a realistic prospect of this site delivering within the 5-year period.
Okay. So, Mrs. Richards.
Thank you. This is another of the sites that were in or are in Homes England ownership, where the council are procuring the site to accelerate delivery. That was also reported to the February 2022 committee, and the acquisition is expected to be completed by the end of March. That timeline has been agreed as per my trajectory with the head of development and placemaking. I acknowledge the meanwhile uses. That's not a new concept, being used successfully elsewhere to generate income and keep some active use on the site. As was mentioned, this is the 4th phase of redevelopment of the wider area. Phases 1, 2 and 3 have already occurred. So I stand by the 100, I think it's 133, I've lost my line now, 133 within the 5-year period, acknowledging that the element of the site with meanwhile uses will take longer to deliver, and therefore that will be outside of the 5-year period.
So it's 220 in total, but you've got 133 in the trajectory, is that right?
Yes.
So if I may, so just picking up on a point, just said to you that it's quite an interesting point to make that the council's acquiring the site from Homes England to accelerate delivery, which is an interesting concept given the role that Homes England are supposed to play, and the fact that Homes England usually has to be involved on problem, difficult sites to help make them happen. That perhaps speaks to the difficulties and challenges to deal with the site. Very understandable the council wants to prioritise that and bring it back within its control. I applaud it for that, but I think that really does exemplify the challenge, which won't be straightforward. You know, given the state of the economy, the challenges for commercial operators. I mean, you'll have seen for yourself the number of vacant premises immediately around the town centre. It's challenging times. So it won't be straightforward, and I think that will impact, because it's a mixed-use scheme, it will inevitably impact on the delivery and the design of the scheme.
You want to come back on any of that, Mr. Richards?
No, thank you.
No? Okay, so we're 342, is that
There's actually an
correct?
additional one, sir, that I've adjusted my position, 677, the one immediately before.
Sorry, say that one again.
So the 677 and 678, which is land at Shipham Lane, Winscombe, and land adjoining Coombe Farm, Winscombe. They're two sites that are next to each other. They're separate in the trajectory because they have separate local plan allocations for 28 and 24. Now, in my proof, I did not, or I accepted rather, the council's position that they would be likely to deliver, and that was on the basis of a current planning application which straddles both land parcels, a single planning application, promoted by Vols Parks Limited for some residential park home type bungalows.
Sorry, page in your proof.
Sorry, forgive me, sir. Page 58.
58.
So I'm sorry, this is sites 677, 678. So we're off the schedule.
We are, sorry. This is the reason for the 3.3 to 3.2 change.
Right, so it's the top of your page 58, yeah?
Yes.
Yes, okay.
So the application had been submitted in November 2020 for 55 dwellings, slightly more than the combined allocation, which in aggregate is 52. The application is in full detail. There were no significant objections raised. A significant amount of work had been done with archaeological investigation. I had concluded there was a realistic prospect because of that planning application, but that planning application was withdrawn confirmed on the 7th of February, which was so recent that it didn't even make my rebuttal. But it's an important development. No reason is given, so I don't have the benefits of that. Ms. Richards may be able to help, but I have a note here which, if it helps you, it's simply the confirmation from the council of the withdrawal of that planning application.
Okay.
I'm happy to introduce it as an inquiry document because it's not otherwise before you if that's acceptable to the council. But so it's really a simple point that now with the withdrawal of that application, as I say, unclear as to why, but it suggests because there were no significant planning issues that it may be a viability issue or deliverability issue for other reasons that promoter didn't want to proceed with the development. So on that basis, there's no current proposal that is deliverable, and therefore I've changed my stance on that, albeit I appreciate very latterly, but that information's only very recently become available, which I believe changes my position.
So your changed stance, if I'm looking at the first line, you're talking about 28 and 24, so we've got 52 in total.
So it would be a reduction of 52.
So the appellant's position on this one is that the supply should be reduced by 52.
That's correct.
Okay.
Shall I give you this?
Oh yes. Okay. So that's,
Yeah.
Just a very simple one-page letter.
Yep. Yes, I recall that. Thank you. Thank you. Which page of your appendix is it, Mrs.
In my evidence, it's covered on pages 105 and 106, which do indeed refer to that planning application, which, as was mentioned until last week, was a live planning application, seemingly with no issues. I mean, exactly the same position. I'm waiting for an email back from the planning case officer. That's a matter of public record. The applicant has asked for the application to be withdrawn, and we've respected their wishes and acted upon that. There are no obvious constraints to me or reasons why, which I think Mr. Patterson-Neild agrees with, having seen the documents on the case file. So I am waiting for a response on that one. As soon as we've got it, I'm happy to share it with Mr. Patterson-Neild in the first instance, and then maybe we can report back to you. Once I've given this evidence, I can go away and chase that response, and we can find out what's happening with that.
Yeah. That sounds like it makes sense because obviously it's hot off the press, as it were. So
Yeah.
Yeah, I'm very content for the council to come back once it's investigated the matter. I appreciate it's very, very recent, so
Yep.
it's fair for them to be able to
So
respond in that way.
watch that space, or watch this space on that one.
But anyway, that's, as Mr. Banner's just indicated, that's the difference in his opening to why we now say 3.2
Yes.
than 3.3. That's just the numerical difference.
And so are we back on
Back on the schedule, yeah,
342.
342.
Yeah.
Land east and west of Weberham Lane in Yatton. So 58 and
108.
108.
Right, I've got your page 58. And what's your page reference?
108, sir.
108. Thank you. Right. Okay. Thank you.
So this is allocated for 24 dwellings, carried over from the previous local plan, which is an important point. Planning permission was refused in 2004 for 24 dwellings. No further applications since then have been made. So it's a very long-standing allocated site, not delivered anything. There remains no clear evidence of delivery. Certainly no details of progress towards a new planning application. There is obviously a history of planning rejection on that site, but just no evidence as to why that should come forward. But concern that I have is that it's been allocated for such a long period of time. It really questions whether that site is deliverable.
Okay. Mrs. Richards, then.
Thank you. The 2004 refusal does predate its allocation status, just to be clear. I believe it was first allocated in 2007 in the replacement local plan. My understanding is this site was previously owned by Persimmon Homes and Crest Nicholson, and there were some issues about who was going to develop it, although we were previously advised by Persimmon that it was in their small site development programme and anticipated by 2026. Since then, I've been advised by Alliance Homes that they're working with another housing association, Edenstone Group, and a pre-application submission was made last year to deliver 24 affordable homes on that site within 5 years. That's why I've got evidence and have included within the trajectory for year 5 at a rate of 24 dwellings.
Okay. Okay. Is that the last one, or have I got
There is one more, sir.
one more?
The brilliantly titled Pudding Pie Lane.
651, yes.
Makes me hungry thinking about it. In Churchill. That's 651, page 58 again.
Yep.
And
111.
thank you.
Thank you.
Allocated for 35. Outline permission granted in 2018 for 35 dwellings. And reserve matters, importantly, was required to be submitted by January 2021. Outstanding series of pre-commencement conditions again. Obviously that time has now passed. Neither an RM nor planning conditions have been discharged, so the permission has now lapsed, which Council fairly acknowledges. And in my view, the site should not be included. There's no clear evidence of a revised proposal, no details of progress towards that. In my view, Council does make reference to Stonewood Homes and ongoing pre-app in Ms Richards' schedule, but that's the only information that we have in relation to that. There's no further detailed evidence of, or no clear evidence in my view of the timetable and the details of when that site is likely to come forward. So I've excluded that on the basis of the recent expiration of that previous permission.
I'm sorry, it's 35 dwellings.
Yes, that's right.
Yes.
Okay. Ms Richards?
Thank you. So that is factually correct. There was a previous outline which was secured by the landowner themselves, which recently expired. Rather than renew that consent or seek to submit a reserved matters, Stonewood Homes have now started preparing their own application, and they have submitted that detailed pre-application submission to us. Within that, it advises that they're intending to submit a full application this time around, taking account of the previous outline, which was approved and therefore agreed in principle, and they're aware of the conditions that were attached to that decision. We've put this in for year 5 of the trajectory on the basis that the planning permission had lapsed at this time. As I say, since then, the pre-application submission has been made, and our timeline takes account of that.
Okay. Right. Okay, thank you for that. That's the end of the allocations, yes? So, where do the parties stand on the small sites then with planning permission?
Thank you, sir. I deal with this actually principally now in my rebuttal,
Okay.
but I also need to refer to my main proof. So page 59 of my main proof and page 2 of my rebuttal. And you may wish to have Ms. Richards' appendix NR2.
Yes, it's NR2 and paragraph 45 of my main proof.
Right, bear with me. So I've got the rebuttal. So NR2. Yeah.
Which itself might not be that helpful to this discussion. It is simply a list of the
Yeah,
sites.
it's quite a big list, isn't it?
Yeah. So that's a full list of those sites that comprise my total figure.
Yeah.
Page 14 of my proof sets out my position on those, if you like.
Yeah. Okay. Right, all to hand.
I think the starting point, sir, is that that list was not available until Ms. Richards, till the exchange of evidence of proofs. So we didn't, the council's initial findings statement from last November did not list or identify individually those small sites. There was it was in the trajectory as 541 as an overall number, which is now explained by that list.
Yeah.
But we hadn't had the chance at that time or I hadn't rather to obviously comment and to review that. So I hadn't at that point challenged the stock of 541, but upon receipt of that...
Can I just pause you and just... I can hear something which is possibly
I can too.
worrying.
I think it's probably a door alarm rather than a fire alarm. Okay, it has stopped. That isn't the fire alarm. You'll
It's
know
not the fire alarm. You see, it sounded like a very small fire if it was
It sounds like one of the fire exit doors, if I'm
Right.
honest.
Okay. Right. So let's... sorry, Mr. Patterson-Neil, you better
No, that's fine.
start
So-
some of that again.
No problem at all. I've obviously now had an opportunity to look at that, and in my rebuttal, in paragraph R4, what I've done, given the great number of those sites, what I've done is looked at the oldest permissions within that list and some of the most recent to understand whether there was a prospect for any of those to have lapsed, or indeed whether any that have been snuck in, as it were, post 1st of April, for want of a better phrase. There is one that dates post-April that I've identified, which I've made reference to that. That's 3 Old Church Road, Clevedon, for 2 dwellings. And therefore that should just not be included for the reasons discussed earlier. But more significantly, numerically, 21 of the sites, based on the information in that table, which indicates that the table is helpful in certain respects, but what it doesn't do is give the date of the permission nor its expiration date. That's not part of the table. I'm not being critical, it just doesn't include that information. So what I've sought to do was to look at, and I've identified in my table R1 a series of sites which were, and I've identified, sorry, the lapse dates of each of those, and those dates are listed in the third column. Now the council's NR2 indicates a survey date of April of last year, and what it does identify is sites that were under construction or not started. So the coloured columns towards the end indicate completed previously, not started, or under construction. And therefore, I've reasonably deduced that because those sites listed were not started at that point, and given their expiration date predated that, they must have lapsed. So that in total accounts to 46 dwellings. That, when you look at the 541 as a percentage, that's 8.5%. Now, I've only looked at 76 of the 541, so what's that, around a quarter, give or take, less than a quarter, 20%, of those units, and yet identified a significant number which have lapsed. Now, in a sense, that's not astonishing. Lapse rates are quite a common issue discussed, as you'll well know, sir, and that reflects the reality that a number of small developments don't ever commence. So what I've done as a consequence is deducted 48 units, the two that were post 1st of April for that specific reason, and then 46. So that's now reflected in my table in my rebuttal, where you'll see I've updated the table in my main proof to reflect that. So that's obviously what I've done once I had the benefit of seeing that table. The council hasn't applied a lapse rate generally to its stock of small sites, but yet the council itself, as I've noted in my evidence, that it did propose a 10% lapse rate to the site allocations inspector, which she notes in her report in CD D5, paragraph 54. So it's something the council has accepted previously, and indeed in the Farley Fields appeal decision I also referred to in 2018, a lapse rate was accepted, indeed by the Secretary of State in that case. In my view, the evidence I've gathered also, I suppose, is notable in two ways. It mathematically reduces by the number I've indicated from the supply, but also, in my view, and we'll come on to this, I suspect, if you'd like me to leave it there, we'll come back to the windfall allowance point, but I think it's important to reflect that this gives further credibility to the position I've taken that there should be a deduction for the non-implementation effectively in that windfall allowance. So I'll leave it there because I think you probably want to come back to windfall as a separate item, because the council takes the first 3 years for the stock of small sites that exists and then the last 2 years for the windfall allowance. So that's a slightly separate point.
Okay.
I'll leave it there.
Leave it at that for now. Okay. Ms. Richards, on the specific points then that Mr. Patterson-Neal's covered and his suggestion at 46 reduction.
Okay, so the application of a lapse rate was previously standard practice, and I accept that has formed part of the council's evidence previously. I'd suggest it is slightly different for a plan-making stage when we're looking over a much longer term than with, again, applying it to a windfall rate perhaps rather than a stock of specific sites which have been listed. I appreciate they weren't available to Mr. Patterson-Neal previously, although they weren't asked for either until they were produced as part of our proof of evidence. That's why this dispute's come relatively late on. Going through that table at R1 of Mr. Patterson-Neal's rebuttal, a number of these permissions also have benefited from the extension of planning permissions that I referred to earlier this morning. Again, I'm happy to circulate copies of that, perhaps with the other bits of information that we're going to provide. That automatically extended consents as a result, direct result of the coronavirus temporary regulations, to take account of the pandemic and the lockdowns and the lack of construction activity. So if someone's consent was due to expire and they weren't able to go out and implement it, they were automatically extended. And that applies to a number of those within that table. There are also a number of sites listed where there has been a technical commencement. So I accept that that's not obvious from the schedule of small sites. I, however, feel it would have been misleading for me to present those as under construction, where someone has solely gone out to do enough to start their consent to stop it from expiring. So they are still shown on that table, which is a published version. There's back office copies which show and have photographs attached where these have commenced in a technical sense. Therefore, they're retained on the list as they will not expire, but there's been not enough construction activity to warrant recording them as under construction.
So in terms of any figures, can you indicate, I mean, is the council saying that none of these 46 should legitimately be removed?
Yes, that's correct. We're saying that 541 remains the figure for small sites as per that big list, and that we anticipate that they will come forward at a rate of, well, we've put in 180, 180, and then 181, so over the initial 3-year period. And as set out in my evidence, I think it's page 14, it is from page 14 and 15, where we've set out that that accords with previous past trend rates, providing reassurance that that's a robust estimate.
No.
Yes, okay. No, not at all. I was, the silence was me busy catching up my note-taking, so that's all that was.
May I just come back on a couple
Yeah,
of
please
points?
do.
I specifically did not include any sites in my list that benefited from that extension due to the COVID regs. So it does not include any of those. That's the first point. And the second point, I take the point, and the table is not entirely clear, again, not being critical as to whether any technical commencement of developments had occurred. I took the view it was reasonable to assume that it hadn't, because if it's 1 or 2 houses, when you start, well, you're building the house, aren't you? I mean, there's no lead-in works of any great significance, like roads to deliver, etc. So I had fairly taken that position. The significance, however, let me put it this way, of Ms. Richards' response is that if she's accepting that a number of these have only technically commenced for the purposes of ensuring an in perpetuity on that permission, it doesn't give any confidence that site's going to be delivered. If they're not actually building the house, it's not coming forward. So I'd still take the view that it's reasonable and robust to make a deduction here. Obviously, it's for you, sir, to consider whether or not you'd like the council to provide any more clarity on the ones that I've reduced. And obviously, there's an opportunity if they wanted to do that. But I think it does indicate that there is doubt to the number that I've listed, whether or not there's been a technical consent. If they're not progressing, that's ultimately the key. Are they progressing or not?
Okay. Anything further? No? Okay. So, I've put down windfall allowance as the last element on this part of the agenda. So, where should I be checking in your
59 in
approved
mine,
page?
sir.
Yeah, 59. Thank you. Okay.
I think page 18, Ms. Richards.
Sorry, page 18.
18, I think.
Right, okay.
So firstly, I agree with the council that they're right to apply the windfall for just the final 2 years, because the stock of small sites exists for that first 3-year period. You'd expect those small sites to effectively be that windfall list that is coming forward. So I agree with the approach as a matter of principle to avoid any double counting. But turning to the rate the council then uses for those 2 years, so mathematically it's derived 176 as an average of that achieved over the last 15 years. So it's clear, the council's clear how it's arrived at its figure, no issue with the maths. The council considers its position as robust because it equates to around 1/3 of the stock of small sites. However, what you see, I think the table in Ms. Richards' evidence is helpful. Table 6 on page 19, which shows the range of windfalls across various key settlements, but in total, the most important column is the one on the right. It shows quite a significant fluctuation over the years, back to 2006, in the rate achieved. I think that's important to note that there has been significant fluctuation. Now, the council has not applied a lapse rate, but interestingly, they applied not a 10%, but a 17% lapse rate in the 2018 SHLA, which is CDE8. And what's really important, I think, is why. Now, I know lapse rates are often considered at inquiries, and many inspectors are concerned with the inclusion of that without any particularly evidential basis for it. Just saying mathematically some don't tend to happen. I know some inspectors are concerned that that's not necessarily good practice, albeit we've seen many decisions where that's included. But interestingly here, the council has a specific reason for that 17%, and it's research-based within specific to North Somerset, of the new build completions that were previously in residential gardens. So as you'll recall, sir, the national policy changed, shifted a number of years ago on support for what's often called backland development, and the policy stance has hardened against the utilisation of that, not least through the change to the definition of PDL, previously developed land. So the council fairly there has indicated and acknowledged that the data for North Somerset indicates 17% in the past was derived from that source, and therefore they were right to indicate that they should deduct that proportion given the change in the way planning policy now treats proposals of that nature. So I consider that evidence base is an appropriate one to use, and have deducted 17% from the council's figure to arrive at my figure of 162 per annum, which I've then doubled to arrive at my windfall allowance for those 2 years. Now, I'll turn back to the point I made earlier about my review of the 70-odd sites from the stock of small site permissions, and that was 8%. So whether one uses 10% or 17%, my view that my review of those sites does indicate that it is legitimate to apply a lapse rate. There is some evidence in 2 places here. One, the assessment of stock of small sites which exist, which is not a theoretical exercise, it's a real exercise, together with the evidence the council itself has used and relied upon in previous work, but it's choosing not to use that now. I think Ms. Richards fairly indicated that the council has used lapse rates in the past. So I think it's appropriate and robust for that to be done, and that's the reason for the deduction that I've undertaken within my evidence.
Okay. Mr. Richards.
Thank you. Previously, the MPPF, the old MPPF, explicitly stated that residential gardens and development of shouldn't be included as part of a windfall allowance. Now, the new MPPF, paragraph 71, doesn't state this. Rather, there's a shift, and it defers this to plan making. Paragraph 71 tells us that plans should consider setting out policies to deal with this, and our adopted plan has one. It's policy DM37 of the Development Management Policies, which is one of the core documents. Policy DM37 is supportive in principle. It does permit infill, backland and garden development, albeit subject to some detailed criteria, such as siting, layout, materials, etc. And we're proposing to carry this forward in the emerging new local plan policy. So I believe that that's accounted for. There is no need, as per national policy, to make a discount for those developments that may come forward on garden land as we did previously. I'd also just go on to say that the rate of 176 I think is robust, it's justified, it accords with the rate that we have anticipated for the next 3 years within the small sites with planning consent. It's based on an average over the past 15 years, the plan period to date. Last year's figure was indeed 176. Mr. Patterson-Neild acknowledges, and I would agree with him, that it does fluctuate over time. Therefore, that's why I believe it's right and proper to take a longer-term average to ensure that that's covered.
Okay. You want to come back on any of those points, Mr. Patterson-Neild?
No, sir, I think I've set out my position. Thank you.
Okay. That was quite a lengthy run through those various sites, but I think we can say that we've dealt with item 2, haven't we? So all I really wanted under my item 3 was just, as it were, to sort of ask each side to regroup and give me your headline figures for the supply as to whether they've differed from the written evidence I've got as a result of any of the discussions or more recent information that may have come to light. So, Mr. Patterson-Neild, if I turn to your rebuttal, is that the...
No, sir. I mean, there's a slight update, really, because of that recently withdrawn planning application, where there's a slight change, and the note that I used at the beginning of the session this morning for some opening comments has that at the back. So I'm happy to circulate that to you, so you've got that. But in summary, we agree on the requirement 6946. In terms of large sites with detailed permission, my view is 1799. That's not changed.
Yep.
And then contribution from large sites with outline permission is 116. Again, that's not changed.
Yep.
From the Western Villages, due to an adjustment because of the St Modwyn email to do with what was completed at the base date and what's forthcoming, I'm now saying 1625. Slight increase from 1610.
Yep.
That's explained by that slightly larger number of units still to be done, as it were, from those reserved matters. Site allocations, through the deduction of that, the double site is now 199. The stock of small sites is now 493. With a windfall allowance of 268.
Yep.
So a total supply of 4500, which equates to 3.2 years.
Okay. Thank you. Ms. Richards, have you got a similar breakdown for me?
I can be brief, sir, and just direct you to the table. My figures in the evidence have not changed. So it is table 4 on page 13 of my main proof of evidence, sets out the component figures for the supply.
Sorry, table 4 on page 13.
Yes.
Yep. Okay.
And that results in a total supply of 7,762 dwellings, which equates to 5.6 years supply using the agreed requirement figure.
Okay. Right. Thank you. Anything further from either
Shall my
side?
colleague distribute the note?
Oh, yes,
Which
yes.
contains that table. I've just...
Yeah, just to confirm that.
I didn't do it from memory. It was all written down in front of me.
That's helpful, thank you. And that's 2, 6, 8, 4. Okay. Anything under the final agenda item, any other matters?
Is it helpful just to very briefly summarise the position and the implication from the position, if you like, reached? To an extent, I'm recovering ground. I don't want to recover ground. I mentioned at the outset, but the 3.2, in my view, is serious and significant. as a deficit. That should be given very significant material weight. Obviously, Miss Fenton will deal with the application of the planning balance and the weight to all policies arising from the evidence that I've presented. But my conclusion is the Council doesn't have a compliant policy to deal with local housing need as required by national policy for the reasons set out concerning CS13. The fact that it was interim, not fully in accordance with the objectively assessed need at that time, and has not been reviewed. It's now 5 years beyond the time in which it should have been reviewed. And therefore 11D of the framework is engaged, and the tilted balance is duly applicable. The weight to be given to those policies CS13 and 14 specific to my evidence as most important policies should be diminished as a consequence of that. Ms Ventham will confirm the weight in the context of all other relevant development plan policies in due course for you, sir. But in my view, the conclusion that I draw is that this site really does need to be delivered now. It is obviously an allocated site and it should be brought forward to address need, and particularly so given the position looking backwards in terms of delivery and the concerns that I've expressed, but also looking forward to the local plan, which itself is going to fall short as drafted, and significantly so. So all of that context indicates the urgency and the scale of need, and that this site should make an important contribution to that.
Just one sort of follow-up point for that. I mentioned in opening, sir, that the fact that the council doesn't include this site in the 5-year supply, when you do, means that it takes the delivery of the site beyond the SAP plan period. So in fact, the plan wouldn't be delivered on its aims. It'd be helpful just to have that confirmed by the council that they agree factually that's a matter, that's correct. What flows from that, obviously, we can make submissions on, but that effectively it would be delivered after the end of the plan period.
Okay, well, yeah. Mr. Richards, do you want to address that point and give me your final summary, as it were?
Very briefly, sir, on that point, it is made clear in the draft plan that this is a plan, a Regulation 18 plan that is subject to consultation. One of the questions within that consultation will be how to address the current shortfall. It's also clear within the plan and the background papers, namely the spatial strategy and housing capacity paper, which we can submit a copy of if that's helpful, that this will be kept under review. You have to take a cut in time, a base point of what's got consent, the stock of supply, and that will be continuously kept under review. If our housing delivery was to increase significantly over the coming year, then yes, I would agree. Additional sites would need to be allocated and identified through that plan-making process. But that is the current base position. We can provide further details if that's required. And the matter of weight to be given to policies is a matter that will be covered by Mr. Muston in his planning evidence.
Okay.
So if I may, just as a final sort of two-penneth, you will have noticed that in the appeal documentation, in the core documents, there are a series of planning decisions made by your colleagues over the years. I think it's right to say that they were all made against the background of the requirements set out in the core strategy. And you will see that the generality of the supply is that it was in excess of 4 years on the whole, and improving. This is something I can obviously deal with witnesses in due course. And so when one approaches these matters, one has to adopt a degree of common sense. And one bears this point in mind, that there is a steadily improving picture in North Somerset. That steadily improving picture being, as Mrs. Richards explained earlier, largely due to the acceleration of development at Western Villages. And when, sir, you combine that fact with the improved housing delivery test, allowing for the fact that the figures under the standard method aren't the same as those for the core strategy. We can deal with that with witnesses in due course. The common sense picture that one forms is that it's improbable that housing land supply is anywhere near as restricted as that urged upon you by Mr. Patterson-Neild, and it is more likely that the picture painted by Mrs. Richards is right. Now, you will decide whether it's right by a detailed interrogation of the sites that are in contention, and you'll form a view. But just to leave you with that thought, please, keep an open mind, because of, as I say, the steadily improving picture illustrated by the housing delivery test, coupled with a good reason for that being what's going on at Western Villages.
Okay, thank you.
Firstly, I don't think, if I missed it, I do apologise. We got an answer to whether the council agrees with that factual point about whether, if the appeal fails, then on the council's own basis, because it's not in the 5-year supply, the delivery of the site is taken outside the SAP plan period. Yes, it is. Okay, good, thank you. Then the second point is the steadily improving picture. I mean, we can come back to the close, but Mr. Patterson-Neild's proof, page 25, 5.9, has the past housing delivery. And I think the steady improvement is in relation to the extent of under-delivery. So they continue to under-deliver, but just less than before. That's the real context of the improvement. And finally, sir, of course, the question isn't really, is it more likely that one or other of the experts is right overall? The question is, for each point of dispute, is the test set by the framework met? And obviously you know that anyway, but just say I put a marker down, that's not quite the right way to frame the question, I'd suggest.
And I agree, sir. What I was seeking to address you on was the picture being painted by Mr. Patterson-Neild of woe. I seek to encourage you to take the view, sir, actually the picture is very positive. As for the detail of that picture, you'll decide in the way my learner friend says. And just to be clear about the SAP, just to make sure I understood my learner friend's point. If this appeal is dismissed, the allocation in the SAP plainly remains, but it has to be delivered in a way which is consistent with Policy SA1, the schedule thereto, and the restrictions that are imposed on delivery. So the site remains allocated, but it has to be delivered properly. I think I've understood things.
No, that's not quite the point. I mean, firstly, it doesn't have to be delivered in Schedule 2's ones are taken into account, as we discussed. But no, the point is simply, I'm not trying to be obtuse, but simply that if the appeal fails because of the council saying another access should be used, the council's view on the deliverability of the site then becomes a post-5-year site. The consequence of that is that this allocation would only be delivered on the council's own case because of the access issue after the SAP plan period, and therefore the allocation isn't achieving what was envisaged by the plan. That's the point. And
I understand. And it was me being slow. Can we ask Mr. Muston to do with that point, sir?
As long as it's dealt with,
Yeah,
then yes, so it's been, yeah.
No, I do, yeah.
Yeah.
Fair enough. I mean, if Mr. Muston could deal with that.
Yep, okay, that's fine, that's fine. Okay, well, we've got round to 3:30. I think that we can safely say we have concluded the discussion on the housing land supply, so that's good. What's less good is the availability of this room for what I thought we might have been able to do this afternoon. I think reasonably we can, if we crack on, we can hear your highways witness in chief, can we? But not begin any cross-examination. So I apologise if anyone's had to make a special journey thinking we'd race through that. It's obviously my underestimate of the time required for the housing land supply. How long are you going to take in chief, do you think, then, Mr. Leader?
Well, so you've read the evidence, have you? So you're familiar with all of the detail.
Yeah.
I can be brief, therefore. We'll get done by 4 o'clock. But before I do that, may I just take instructions from Mr. Kent on a particular matter?
Yes, I was going to say, we've been going for an hour and a half. We can have a 10-minute adjournment if that's not going to then cause problems with...
At 4 o'clock, sir, tell me to be quiet, and then I will.
Well, my understanding is that we have to be out of the room has to be cleared by past, but we've been given the 4 o'clock to make sure that there's enough time to do that. We do need, obviously, to discuss time tomorrow because we're going to be in a different place, in a different room, aren't we?
I'll stop at 4, then we can do that.
We'll do that then, yeah. Okay, let me adjourn then now, and we'll resume at 3:40. Thank you. Well, the inquiry is resumed then, ladies and gentlemen. So, Mr. Leader, would you like to introduce our witness, please?
Thank you very much, sir. Good afternoon. I would like to confirm your name is Steve Thorne.
Yes, Steve Thorne, Strategic Transport Policy Manager for the Council.
Thank you very much. And you tell us at the start of your proof of evidence you have a Master of Science degree in Transport Planning and a Bachelor of Science degree in Geography, and you're also a qualified teacher teaching geography in your past.
Yeah, a long time ago now.
A long time ago. You've got 20 years experience in the Transport Policy team at North Somerset Council. You tell us what that involves. And you tell us you're the manager responsible for the team of officers who provides responses to planning applications on behalf of the Highways Authority. And you confirm that the evidence in your proof is true to the best of your knowledge and belief, and that the views you express represent your professional opinions. Now, is there anything in your proof that you've come to discover is wrong and you wish to correct?
Can I just interject before Mr. Thorne answers that? You might want to try and move the microphone a bit closer to yourself. I don't know. Do these things physically move on the table? I'm just conscious of the fact that you're quite a bit further away, and as is always the case, I don't have a problem hearing because I'm sitting very close to you, but I'm not quite sure whether the live stream picks it up or...
Picking up? Yeah.
It's not brilliant. You might want to do more of an Elvis Presley.
I think when I use these, I normally speak too loud.
Yeah.
It's the opposite.
Okay.
Right.
Okay.
Good.
Apologies for the
No, that's all right. So is there anything in your proof of evidence that you've come to discover post-exchange of proofs you need to correct?
No.
Good. Well, thank you very much. Now, if we're going to complete this examination in chief by 4 o'clock, and in order to do that, let's try and canter through the various sections of your proof of evidence. Now, you tell us in the introduction that you have looked at 3 potential access points. One is called Grange Farm Road, one is called Dairy Close, and one is called Yatton Rugby Club. Yes?
Yes.
Now, if we take up your appendices, please, and go to, first of all, plan. Forgive me. ST3. We see on that plan a number of roads indicated, and just to be clear, the inspector will know where Grange Farm Road is, and the inspector would have seen the access to the site, the potential access to the appeal site on his site. Am I correct, sir?
That's correct, yeah.
Good.
Yeah.
Can you just indicate where the Dairy Crest access point, or the potential access point that you've decided to eliminate via Dairy Crest would be? Where does it sit in relation to the Grange Farm Road access?
So it joins North End Road by the R of North.
I'm just wondering, sir.
It's between Grange Farm Road and the football ground.
Yeah. So, in view of the fact we are discounting that as a potential access, we can provide you with a more detailed plan if you want, but I suspect there's no need to.
Well,
so,
ST5 in the evidence I'd seen previously,
yes,
which I think possibly addresses this point.
That's right. If we look to the northwest of Grange Farm Road cul-de-sac, we see another cul-de-sac. Do you see that? And there's a dwelling between that cul-de-sac and the rugby ground. Yep. Is that this Dairy Crest Road?
Yes.
Thank you very much. And you say that that potential access point ought not to be considered to be suitable for 2 reasons. First of all, its geometry. It's too narrow, and secondly, there's a house in the way.
Yeah, so it's too narrow to allow a footway to be provided and still allow 2 vehicles to pass. And as you say, yes, a house would need to be demolished in order to get through to the appeal site.
Thank you very much. So, turning to Grange Farm Road itself, you tell us in your proof of evidence at section 5 why, in your view, Grange Farm Road is capable of providing a satisfactory technical solution to the issue of how to access the appeal site without using Moor Road. You've looked at issues of width, you've looked at issues of road safety, and if you would just tell us, please, do either of those particular matters indicate there would be any degree of complication in providing a technical solution to the need to access the appeal site from Grange Farm Road?
No.
Now, did you have conduct of responding to consultation from the planners on this particular appeal proposal?
No, not personally, no.
No. When your department was consulted, do you know whether or not they were asked to comment upon the question of whether or not a satisfactory access could be provided in technical terms from Grange Farm Road to the appeal site?
Not that I'm aware of. I think that perhaps the main issue was probably the this 12-metre section of unadopted highway.
Yeah.
And then it became more of a planning issue.
Yes. So, to be clear, when the planning application was determined, had your team been consulted on the feasibility from a technical perspective of accessing the site from Grange Farm Road?
No, we hadn't assessed the proposal.
What was your team's involvement in the planning application?
So the involvement of the team was to assess the proposal that was in the application, and I do recall following one of the committees the suggestion of the alternative access to the east of the Reen, to the east of the site, but I think there was a prospect that we would assess that at some point, but it was ruled out on ecology grounds, so we didn't.
Okay, thank you. So, so far as your team was concerned, its only involvement in the planning applications led to this appeal was to answer the question, is the proposed access from Moor Road acceptable, to which the answer was yes.
Yes.
From a technical highways point of view, it is. Fine. Good. So, just to finish off the evidence on Grange Farm Road, could I ask you please to pick up your plan ST2? And slightly inconvenienced because I gave my copy of plan ST2 to Mr. Kent just now, but I can remember it sufficiently to be able to ask you these questions. First, if you, thank you. We've got two sides of A4, a plan on the first side labelled ST2, a photograph of the unadopted access beneath it, and then over the page there's something headed Land Registry Titles Plan. Yeah? Just turning to that Land Registry's title plan, the one thing that I immediately noticed was that the title number is not actually stated. So if one is looking at the area outlined in red, within which there's an area of yellow shading, what we don't know is the title number to that plan. So I'm going to, if I may, just lead the witness in this way. The title number is in fact ST 176709, and there is corresponding with that title number an office copy entry of the property register. Now, I don't think this is in evidence. It's alluded to by Mr. Muston. So what I'm going to do in order to save time is simply to say this, that if one looks at the office copy entry and also looks at the plan of the title that's filed with it, which is the plan you see at ST2, but unfortunately without the box that tells you the title number, the property register shows you that the title plan and the title number 176709 is the land shaded yellow, but more to the point, the proprietorship register tells you that that land, freehold of it, is owned by Bryant Homes. Now, Mr. Thorne, looking at the plan, do you see that if one follows the cul-de-sac, which is Grange Farm Road, to its northeasterly extent, there is at the end of it an oblong just beyond the extent of the highway, which is marked by the dotted black line? Yeah?
Yeah.
Do you happen to know whether or not that is owned by Bryant Homes?
Only insofar as the yeah, so it's owned by Taylor Wimpey was my understanding.
Well, I've led you rather horribly. I've more or less told you it's Bryant Homes. So I'm going to hand in a copy of the office copy entry. It is in fact owned by Bryant Homes. I had a feeling we were going to end up in that particular situation, but there we have it. Right. Now, finally, galloping through all of this, Yatton Rugby Club. You've indicated that, in your view, it's possible to form an access into the appeal site through Yatton Rugby Club. Please tell the inspector why you think that.
So the front of Yatton Rugby Club is adjacent to the highway, North End Road, and there's two accesses existing onto North End Road. There's also a continuous footway for sort of 100 metres across the front of that site, which would allow pedestrian access. We had a look at the accident record, and there are two recorded injury accidents in the last 10 years. I think both were in 2018-ish, but neither of them involved turning movements. They're both slight injury accidents. Neither of them involved turning movements, so therefore can be considered unrelated to those points of access to the rugby club. And so I think from a highway point of view, either of those accesses could potentially be used, or a new access could be created somewhere on that frontage, and then it would be a case simply then of linking through to the appeal site across the fields that make up the rugby club.
Have you been consulted about any particular proposal to gain access to the rugby club for redevelopment?
No, we've not commented on a formal proposal, presumably because there's not really much of a highway issue there.
So you're not aware of any proposal that's been put forward to the planning department of this authority?
No.
No. Your assessment of the scheme, can it be said to be anything more than hypothetical?
Yes, because we don't have a proposal to assess.
All right. Well, sir, thank you very much. I don't think there's any benefit in examining this witness any further. Witness any further in chief. But may I put in the property register that indicates that Bryant Homes own the particular piece of land that you see photographed at ST2, and I'll make sure that by tomorrow morning you've got a properly headed up plan which indicates the title number corresponds with the yellow area that you see on the second page of ST2.
Yep. Okay, well that seems fine, thank you. So we'll, so that concludes the evidence in chief. So tomorrow we'll begin with the cross-examination,
Yes.
but we need to talk, we need to talk both about tomorrow
Yes.
and the rest of the inquiry. So just let me make a couple of notes here, please. Let's just deal with tomorrow to start with, because we're at the Grand Atlantic Hotel, I understand. Presumably there's the name of a room that we've got there. Does someone know
Yes, we've got the ballroom, which is on the ground floor. There is car parking arranged for anyone who needs it. Please park your cars within marked spaces in their car park and then report to reception of the hotel initially, where there's an iPad for you to put in your registration details. You can carry your boxes through, or we can convene in the ballroom. You'll be directed there by reception, and then we can bring them through a fire exit down there rather than carrying them through the hotel.
Okay.
Could I beg you, if possible, could we have a slightly later start tomorrow, just for the reasons I've alluded to in the email correspondence?
Yeah, later than what? Later than 9?
Later, later. I'm just wondering if I could...
I was certainly going to suggest later than 9, because having moved to a new venue...
Either 10 or 10:15, just because I'm going to have to do some overnight work and there's only so many hours.
Well, I was going to suggest 9:30, but if you're specifically asking me for 10...
Would you mind, sir?
Are you content with that, Mr. Leader?
Yeah, thank you. Take the hit for the team.
Okay.
Thank you, that's really
10
kind.
it is,
Thank
so
you.
we'll start at 10 tomorrow. But let me find my notes. So basically, we've got a new venue just for tomorrow. I understand that there aren't time limits on the room there, but obviously we don't want to sit unduly late, so I'd still be looking for 5:30-ish as going to. Hoping that we can do possibly a 9 o'clock start. It might have to be 9:30 on Friday, but the point I think I'm getting round to is looking at the time estimates that you both gave me. We now do seem unlikely to get through all the evidence by close of play on Friday. You seem to be frowning, Mr. Leader. Have you calculated it differently?
No, I think we might do better than that, sir, because I haven't got much from Mr. Banner's highways witness. I haven't got much from Mr. Banner's landscape witness. Okay. I have some questions for the planning witness, but it's not going to take 3 hours.
Okay.
I sort of agree. Just to be very clear, if it helps, Mr. Lee, that the planning witness will do with land ownership issues rather than the highways witness. So if we can get through everything but planning tomorrow, then we probably will.
Okay, well, let's...
I think that's
okay, I'll take back what I've said. Well, no, I'll caveat it, say I based it on the estimates you'd given me, and on that basis I thought we were unlikely to do that, such that I was thinking we've got Tuesday and Wednesday of next week. We might need to call on the Tuesday, because one thing I wanted to float with you is when are we going to have a meaningful attempt? Well, no, first of all, when are we going to deal with conditions in Section 106 and the site visit? I know I said this morning that in some ways I can see merit in not doing the site visit until I've heard the biodiversity and ecology evidence, but equally knowing that when we come back it may be for a more constrained period, and we have got some days next week. I'm thinking perhaps there is merit in me still doing the site visit on the Wednesday that I'd originally thought, which might have implied that we've been here on the Tuesday doing something. These are sort of just thoughts as opposed to anything definite.
In terms of conditions 106, my inclination is there's probably some advantage in having a first go, recognising that we may have to come back to some of the ecology-related conditions afterwards, but it may actually help bring up a degree of focus to the ecology discussion. So that would be my initial inclination. I'm seeing nods by various people.
But that being Tuesday?
I think so. I mean, I think
it would be hard pressed to fit in all the evidence and a meaningful
I think that's right.
there.
I mean, I think where I'm getting to in my head is probably, famous last words, we can release Wednesday to Friday next week, but keep Tuesday in is probably what it's looking like.
Yes, and by release Wednesday you mean as a sitting day, but I could still do the site visit if need be.
If arrangement, the council could free up this room, people would need to book hotels unless they were doing the site visit, that sort of thing, that we'd work on the basis we come back on Tuesday to cover what we don't do this week, but site visit Wednesday, but no sitting Wednesday, Thursday, Friday next week.
Yes, that's...
So, I mean, what would be helpful is just to sketch out a draft timetable. So if we start with Mr. Thorne's cross-examination tomorrow, I don't know how long that's going to take. Then I'll call Mr. Muston, and you've read his proof. We need to get on with things. I promise you I won't be more than half an hour in chief. And then my learned friend can cross-examine him. We ought to get that done by, I would have thought Mr. Thorne and Mr. Muston then, therefore done by lunchtime.
I think so. I can't commit because I haven't prepared the cross-examination yet, so my hunch is yes.
Well, if we've got a 10 o'clock start, we are going to be that bit later. I mean, it was 3 hours 50 minutes for Mr. Muston with your 1 hour evidence in chief. Well, obviously you've just halved that now. You've got 2.5.
I think it's going to be less. I mean, it is only literally a hunch because of the situation I'm in, but my hunch is that if it's not by lunch, it'll be shortly after lunch. That's just a sort of flavour where I've got to. I can't promise yet, but that's.
Well,
what I think.
let's work on the basis that by lunchtime there's a good chance we've completed the council's case on the two witnesses that you are calling at the minute. Yeah. So then we'd be moving on to your highways in the afternoon.
Oh, I'm so sorry.
Yes, sorry.
The dates. I do apologise. Looking at the dates. Yes, it'll be Mr. Mansell is first up, and then which at the moment, apart from he's got one. I think there's a typo. He's got an erratum sheet for which I can circulate now if that helps. I'm not sure. I need to examine him in chief, but all but bar one question. But he's here principally in case there's any members of the public. I think you want to ask him questions about the highways issues.
Okay. So then you're moving on to Mr. Smith.
Yes, and he sent me a note of what he would like to say in chief. My sort of gut feel based upon that notice, it's going to be about 30 to 40 minutes if we don't read the summary, maybe a bit less. Again, that's a gut feel because he's just sent me some bullet points, but that's I think he's at probably.
Yes.
In cross-examination, which means that on Friday, if we don't finish Mr. tomorrow, we will finish him Friday, and we can also then, I think, quite comfortably deal with Mrs. Venterman. Well, we're done.
If we're dealing with Mrs. Ventham early on Friday, then there's an outside chance we can deal with conditions in Section 106. But I'm loath to pass up next Tuesday as a potential sitting day and try and cram everything into this week and then find that we haven't achieved that.
I agree, sir.
So at the minute, so say I know people have got to book hotels and what have you. Shall we work on the basis that we will sit next Tuesday to deal with conditions in Section 106 and anything else that we don't manage to finish this Friday?
But what it does mean, sir, is that whereas the timetable is looking a bit ragged, it's actually looking quite positive now. You've got a bit of time in hand, potentially.
Yes, yes.
The one thing I've just been alerted to, which we'll check overnight, there may be an issue about whether the solicitor who's done the Section 106 is able to attend on Friday. If that's the only showstopper, he might even be able to come on screen, to be honest, and do it on screen.
Okay.
But we'll just explore that this evening and let you know.
See what, yes, okay. And then looking longer term then, for the resumption, if by next Tuesday I adjourn, I'll need to have set a date for us coming back. Now, I had indicated before my availability. So, I mean, I rightly or wrongly, I've still been working on that first week in April. Now, I don't know whether that fits in with others.
I can't do the Friday. On a purely personal basis, because I've always had to rearrange it, I prefer to do Monday, Tuesday, Wednesday, but if that wasn't convenient for you, Mr. Leader, I could do Tuesday, Wednesday, Thursday, but it'd just be more difficult.
And that's week commencing 3rd of April?
Yes, Sunday the 3rd of April. Yes, so it'd be Monday the 4th, Tuesday the 5th, Wednesday the 6th.
Sorry. So, Monday, yeah. Can I just say, just what we were discussing earlier about closings. My preference is always to hear closings in person rather than in writing, simply because I sometimes have questions. And, you know, I can't do that if I've just got something in writing. We could do it virtually, but obviously if it's convenient that everyone's together, we can still do it that way. I could potentially do, as I say, a Monday afternoon and then a Tuesday. We don't know how long the ecology evidence is going to take, because I've got your initial estimates, but equally, if there's discussion and some agreement, then that time may concertina a little.
I agree, sir. I mean, my feel, again, at this stage, is if the no issues are resolved or narrowed, it's about a day and a half, give or take.
Yes.
So a Monday afternoon plus a Tuesday would be enough.
I thought Monday afternoon and Tuesday, sorry, I think I was still thinking site visit then, but I'd be happy for us to have closing submissions on, say, the Wednesday afternoon to give you the...
That would be, because obviously we've got to prepare everything else.
The morning,
now and then
yes.
Anyway. So that, I think it would be prudent to allow for example, a Monday afternoon, Tuesday, and then a half-day Wednesday for closings. If it looks between now and then the ecologists have got to the stage where it's only going to be one day, we can let you know.
Yes. Yes.
It may be.
So,
There's some encouraging sounds at lunchtime, but it's early days.
okay. Well, obviously I don't need to affix the time until I actually adjourn, so that's going to be next week.
Yes.
But you know, if the parties can be alert to that and let me know whether it seems as though it's going to make sense to resume at, say, 1:30 or 2 o'clock on the Monday afternoon, on the Monday, to actually have the Monday afternoon as a sitting session, and then Tuesday and Wednesday, or whether we can safely just come back on the Tuesday and have Tuesday and Wednesday.
Yes. Sure.
Okay. Anything on that?
No, so I would have just suggested we come on the Tuesday and aim to finish at the end of the Wednesday. That's just going to be tidy, isn't it? Assuming that Mr. Phillips and the other ecologist, Mr. Clarkson...
Well, again, I only hesitate in case what was said the other day, if as a result of the biodiversity ecology evidence, then your planning witnesses need to be recalled to mop up things. So I was trying to be safe with my Monday afternoon, but I won't make any decision until we adjourn.
Thank you, sir.
Until I adjourn next week.
What I'll do in the meantime is I'll ask my clerks, and suggest maybe Mr. Lee does the same, just to book out 4th, 5th and 6th. Or pencil it in.
You say 3rd, 4th and 5th.
Oh, is my diary...
Have I got that wrong?
4th, 5th and 6th.
Is a weekend.
I'd be super keen.
So it's...
April the 4th is a Monday.
Oh, right, okay.
I think you got me worried there for a moment, so that way in the
That's
right
okay.
year. We're still in
I'll change that
2021.
then. I hadn't got a calendar in front of me when I did that, so I was working on Monday being the 3rd, but no, that's okay. The 4th, 5th and the 6th.
Cool.
Okay. Okay, well, I won't delay matters anymore. We do need to be out of this room, but so, Ms. Leader. No, but I did say I would let you have them, so I'll try and ensure I get something to you via the Inspectorate's case officer by first thing tomorrow. Okay, so yes, I will do that, yeah. But on that note, I think I can... Oh, and I need the attendance list back, so if that's still doing the rounds, if there's anyone who hasn't yet signed it, if you can put your details on that and then let me have that back, please. But on that note, I'll adjourn now and we'll resume tomorrow at the Grand Atlantic Hotel at 10 o'clock.
Thank you.
Thank you.